Hi, I'm Brian Chandler. I'm a member of Protorae Law, a business law firm located in Tysons Corner, Virginia. My clients frequently ask me questions about non-competes and non-solicitations. I'm here to discuss a couple of these questions with you today. First, my clients frequently ask me the difference between a non-compete provision and a non-solicitation provision. Both these provisions are frequently included into employment agreements. A non-compete provision actually bars an employee after leaving their employer from actually competing with the employer in their business. A non-solicitation provision usually bars an employee after they leave their employer from soliciting the client's business or even sometimes vendors or employees of their existing employer. One question frequently asked is whether non-compete provisions are governed by state or federal law. Well, non-compete provisions are usually governed by state law. Usually the state where the employer or employee are located, or if there's a choice of law clause in the contract or non-compete provision, frequently that choice of law will govern which state's law applies. This is important because state laws vary widely as to their interpretation of non-competes and to determine whether or not those non-competes are in fact enforceable. Another question frequently asked is what happens if a court finds that a non-compete is too broad? Well, again, courts in different states treat this differently. In some states, they do what is called a blue pencil of the non-compete, meaning a court will evaluate the non-compete, and if they find that portions of it are too broad, they'll sever out those portions of the non-compete which they consider too broad, and if it's possible, enforce the remainder of the non-compete provision. Other states redline the non-compete provision if it is considered too broad. This is a more active approach, whereby the judge will actually go through the non-compete and, if it is considered too broad, reduce the provisions of the non-compete such that it meets the maximum level of breadth provided for under that state's law. Other courts, and this is the case generally in Virginia, take a more cut and dry approach to non-competes. If the provision is considered too broad, the court will, by and large, refuse to enforce the non-compete provision.